Be ready. Start. The above read petitions are with regard to the demand of arrears of Vidyalaya Vikas for the period from 2013 to 19. Para. The petitioners in WPC number 9541 of 2020 is the Kendriya Vidyalaya Parents Association and the General Secretary thereof. They had challenged the enhancement of the Vidyalaya Vikas by order dated 19/3/2013 by filing WPC number 13900 of 2013 before this court. An interim order was passed by this court in the writ petition. The second respondent therein filed WA number 1353 of 2013 challenging the interim order. While hearing the appeal, the writ petition was also called for and heard, and the writ petition was dismissed. The said judgment is reported in Kendriya Vidyalaya Parents Association versus Union of India 2014 3 KLT 127. The matter was taken before the Apex Court. Before order dated 24/11/2014, the Apex Court issued notice in the SLP and the petitioners were permitted to continue paying fees at the unenhanced rates. Para. However, by order dated 26/11/2019, the Supreme Court declined interference in the judgment of the division bench and the SLP was dismissed as per Exhibit P to order. It was held that the dismissal of the special leave petition will not stand in the way of the petitioner making representation to the management to waive the difference of charges amount payable, including to provide suitable installments. It was further held that such representation should be decided on its own merits and in accordance with law. The last two paragraphs of the order read as follows. Therefore, we are not inclined to interfere in this special leave petition. The special leave petition and pending application, if any, are accordingly dismissed. Para. However, the dismissal of the special leave petition will not come in the way of the petitioner to make representation to the management to waive the differences of charges oblique amount payable, including to provide suitable installment. The representation be decided on its own merits and in accordance with law. Para. WPC number 1162/2020 is filed by parents of students of the various Kendriya Vidyalaya schools in the Ernakulam region. They contend that they were unaware of the filing of the earlier writ petition by the association, which did not represent them and was only a paper organization with few members. The learned senior counsel appearing for the petitioner submits that the petitioners did not challenge the enhancement of the Vidyalaya Vikas and that they were prevented from paying the amounts only due to the misguided actions of the official respondents. It is therefore contended that the demand and arrears from the current students who did not challenge the enhancement is unsustainable. We are of the view that on a consideration of the provision, the second respondent appears to be correct in pointing out that it does not have an obligation to provide free education except to the extent provided of the Act. Even though S3 appears to provide for a right to the child, we must notice that as far as the obligation of the schools, which falls in various categories as defined in section 2, is concerned, it is specifically and expressly set out in section 12 of the Act. As far as a school run by a state or a local authority, in respect of all the students admitted in such schools, these students are entitled to compulsory free education. Stop.